Standard denies a lot of disability claims, and we've all reviewed thousands of long-term disability denials by the standard. And when a person's been denied by the standard, the only remedy they have is to file an appeal. And as you guys know, this appeal is governed by ERISA. And many of the people who are watching this video are like, I got this letter, they denied me, and they said something about ERISA. I have no idea what it is. I have 180 days to do an appeal, and I need help. And so I want to talk about what we do to help people with these standard denials and what they should expect moving forward. So, Alex, when you first get this call, someone says, hey, I've been denied by standard, what do you need to see and what are you immediately thinking to make someone at least know what lays ahead for them?
Well, the first thing I have to tell them is do not rush an appeal, whether you hire me or hire anybody else. Sometimes people are like, I go, have you already filed an appeal? Yeah, I told them I want to do an appeal. And I go, well, you have to call them and tell them to stop. Because as soon as you file an appeal, the clock starts ticking for the insurance company under the ERISA laws. So do not file a quick appeal because your appeal is the most important thing you can possibly do for your case. But what I want to see is that denial letter. I want to see that, like we said earlier, Standard is very thorough in denying their cases. I want to see that denial letter. I want to see what they're hanging their hat on to deny their claims. Because when we file this appeal, we have to be armed with a whole arsenal to combat the reviews that they're relying upon or the IMEs they're relying upon. So there's a lot of background work that we have to go into before we do any appeal. And the first thing I need to do, see the denial letter. If I'm representing this person, get a copy of the claim file. Claim file is a document that they're charged with under the law to create, which includes all documentation that you've submitted, that your doctors have submitted, that they have commissioned or compiled on their behalf. They have to give it all to you. There's nothing hidden here. They have to be an open book. So they give you this book, which sometimes it could be a couple hundred pages. Sometimes it could be the size of a couple Bibles, a couple thousand pages. They have to give everything to you. And once I get that claim file, I have to tear through that thing. I have to figure out where each reviews are, where the SOAP notes are, because sometimes there's little nuggets in their SOAP notes about what they're thinking or maybe where they messed up. I got to find out where they messed up. I got to find the reviews.
What are, we're using lingo that people don't know. What are SOAP notes?
So those, actually, I always forget the terms of what
don't worry about the abbreviation.
It's acronym.
It's an acronym
I always forget it. My
something.
friends in the insurance industry know it. But it's basically the notes, whoever touches the file there, they have to keep notes of what they're doing every single step of the way. And sometimes you'll find little nuggets in there where there could be a mess up, where they messed up here and messed up there, or what they're thinking. So you can kind of not cheat the system, but find something or an error in their ways, or find an error in their thinking, or find something that you can maybe predict where they want to take this case. But either way, you got to find the SOAP notes, you got to find the reviews, and you got to tear apart those reviews, because if my client's telling me they're disabled, there has to be something wrong with these reviews. These reviewers are typically in-house or independent physician reviewers that are hired by Standard to conduct a review and summary of the medical records. And if my client is telling me that they're disabled and I believe the medical records are supporting the contention that they're disabled, these reviews have to have holes in them. So I want to find these holes. And then by the time we file the appeal, we'll get updated testing done, whether it's a FCE or neuropsych or whatever is needed for my client's claims. And we're going to use the results of those testings and plug those holes and fill those holes with our updated objective evidence, so that when we do the appeal, we have so much objective evidence, so much support from the treating providers that even though Standard does a thorough job in denying these claims, that we're going to overwhelm them with support that they have no, there's nothing they can do but reinstate the benefits or approve the claim for benefits.
So Stephen, I want to get a little bit more detailed with you in terms of, you go through the denial letter, you go through the claim file, which can be massive, as Alex said. And then you start thinking about your tools in terms of what you're going to now use in order to give your client the best opportunity to win this appeal. And I often tell potential clients when they call us, say, it's not so much about the way in which we write your appeal in terms of what we submit. It's all about the evidence that we're going to get, because the disability company could theoretically just say, okay, I saw your lawyer wrote this 10 or 15 or 20 page explanation as to what they thought went wrong. But at the end of the day, it's the facts that matter. So how do you work with the client and the doctor to get the medical evidence you need in order to win your appeals?
Yeah, and I think there's one caveat, like we discussed in a prior session with Standard, and the way they write their policies and the level of limitations they have. So you could focus in one area of trying to prove, say, a back problem condition, but you may walk yourself into a 24-month limitation. So it's always kind of understanding what the policy language may be applying to the specific case, and then seeing how you can work within that, right? Now that aside, that nuance aside, it really comes down to, I think simplifying things to the most common denominators. Are we dealing with a case that's mostly derived on physical restrictions and limitations, mental, emotional, cognitive, interplay of all three? And what information may be lacking? Because, normally complaints of pain or, fatigue, just getting tired, those are all subjective. Insurance companies are always going to attack subjective complaints, saying that there's nothing to document and verify. So in your toolkit, you'll have certain testing, functional capacity examinations, work simulation exams, things that can give a nexus between your diagnosis and how it results in a disability. So looking at those levels of cognitive testing that can be done. And if there's testing I think that can be done, be it cognitive or physical, I'd like to do those first prior to then coordinating with the treating physicians. Because sometimes doctors they believe and they want to support, but when they see questionnaires, especially attending physician statements, and they fill them out, they're like, well, this doesn't really apply to my patient, or I don't know exactly how long they can sit. So doing these testing also allows them to, reiterate and fall back on that for it. So I like to do the testing first, and then start working with the doctors and how we're going to use that testing to support the doctor's opinion and also counter the opinions of the insurance company's doctors.
And I think exactly along the lines as to what you just said about getting that medical evidence, and the doctors often don't understand what's going on. Alex, talk about how important it is to present the occupation to the doctor and then obviously to the insurance company, because sometimes they get the occupation wrong, or when we're dealing with the standard, it's any gainful occupation, but the standard usually does a national economy, the way in which the job's performed in the national economy. So I want you to speak to these doctors get something from disability and they think it's just about their ability to function. And most of our clients can function in a normal life, but it's specific to the job. So how do you get the doctor to understand that and then provide that information to standard?
Either through myself or the client, we have to speak with the doctor. And so the doctor has to understand what the specific requirements are of my client's occupation or my client's training, education, and experience. Because a lot of times the insurance company will reach out, do you think this person can do a sedentary job, or do you think this person can work? And the doctor says yes, and the doctor sees them for 5 minutes every couple of months, and they just check mark yes.
Or can they lift 10 pounds and sit for up to 6 hours?
Right. But so the doctors a lot of times don't give a lot of thought into what the question really is, or they don't know what my client's occupation is. Maybe they just think, oh, he's an accountant, or he's this, that, and the other. It's something basic, and there's a lot of nuances that each occupation requires, whether it's sitting all day, whether it's lifting 50 pounds, or whether it's using your brain all day. A lot of occupations require a user brain. If you have cognitive issues, maybe you can do it for 30 minutes at a time, but after that, you're fatigued for the rest of the day. So doctors need to understand the nuances of each occupation for their own occupation stage of the claim, of course. When it comes to any gainful occupation, it's important for what we do a lot of times in vocational studies, vocational reviews to come back, because we know standard is going to do their own vocational study.
But you're talking about working with an expert.
With an expert. But going back to the doctors, they have to understand what your training, education, experience is, because it's not just whether the client can do a sedentary job. It's whether it has to be something in their field, So most fields are pretty similar. Any occupation is pretty similar to what the previous job was, unless it was a heavy duty job or a physical job. Then yes, you can kind of dumb it down to a sedentary job. But for the most part, especially cognitive requiring jobs, it's still going to be the same whether it's own occupation or any occupation. The doctors have to consider that when giving these opinions, because we don't want the doctor, because again, the insurance companies will take a check mark and run with it. And the doctor takes 2 seconds to do a check mark, and I've seen cases denied just for one check mark alone, and it's a very frustrating experience. But you need to speak with your doctors, or we have to speak with the doctors to make sure they understand everything that's going on before they fill out any forms. And we draft up our own forms. The insurance companies send forms out to the doctors, but we draft up our own forms for every single one of our clients, and either we send them to the doctors, set up a phone call with the doctors, or we send it with our clients. So the next time they go to the doctor's appointments, they bring it with them. That's the best thing. When the doctor fills out the form with a client there with them, and the best, I guess, is when the client's there with them and then we're on the phone at the same time. It's the best way to fill out a form to make sure it's done correctly, to make sure that the insurance companies can take a check mark and run with it.
And in that vein, I think it's also important, Greg, because in asking Alex about how you coordinate with the treating physician to understand the job, I think it's also really important to understand that when the insurance companies have their doctors review it, the doctor who's getting it may know what the job is, but the doctor who's reviewing isn't determining if you can do your job. The insurance company's like, he's only determining if there's restrictions and limitations. Right. So if it says, oh, there's sedentary restrictions and limitations, they would then rely on their vocational, say, well, this job's sedentary, and they'll go that way. So they kind of do it in reverse. They kind of try to keep their doctors in the closet with what the duties really are. And I think that's why it's so important with the treating doctors to circle back, like Alex said, to really get an understanding that this isn't, like you said, your ability to do activities of daily living, which insurance companies will love to use that as a basis of a denial. But the policies are, can you do your job or a job similar in nature?
And in any appeal, you really need to stress this vocational issue, because what I see that when Standard does their vocational studies, they only rely upon, the person who does the vocational analyst typically only relies upon the reviews and opinions of those commissioned by the insurance company. They pretty much ignore the treating provider's opinions on whether the person can do a sedentary job or whatever the restrictions and limitations are. So I always stress how, what my doctors are saying, and how the vocational analyst should not be overlooking the opinion of my doctors and the restrictions and limitations given by our clients' treating providers. Because that's a common thing. They always ignore, the vocational analysts always ignore the opinions of the treating providers. So you have to stress that hard in the appeal.
The last thing I would say, just to touch on again, because I know when we started this video, you said don't rush your appeal. But what I want people to really understand is that you only get one bite of the apple. And it's so much so that, let's assume someone does their appeal, Standard makes their final decision, and it's over. And then the next day, God forbid, they get in a horrific car accident and they need a back surgery. None of that evidence is coming in. It is done. Once you get that final thing, it's over. You can never bring anything else in. You never get another opportunity. Because of that, I find the appeals are more important than even the lawsuits, because you want to win it right here and right now. And you can get everything and anything into this appeal, any kind of medical research, any opinion from any doctor, any YouTube video you want to put in, any statements from any friends, family, coworkers. You can go see 100 doctors and have them opine that you can't do your job. So we try to get as much information as we can in, because we can't do it later. And then the court, if you lose the appeal, has to look at everything. And the insurance company has an obligation to look at everything. So people need to really keep that in mind. And obviously we're thinking about that as we do our appeals, that this is our trial right here, right now. If we lose, we're anticipating to have all this evidence to be able to argue. But having all the evidence and then the way in which you write the appeal is a whole nother art, because you can't tell the Standard every which way to go. So what I encourage people to do is to send us their denial letter. We'll immediately take a look at it, provide them with a free consultation. No matter where you live in the country, whether it's Alex, Stephen, myself, or any of our lawyers, we are available to assist you. We'll never charge you any fees or costs unless we recover benefits for you, and we look forward to speaking with you.